In February 2026, Colorado became the first U.S. state to require companies deploying AI in high-stakes decisions to assess its impact annually and notify affected individuals. It covers housing, employment, credit, education. It does not cover criminal justice. Before we open this door, here is what it means when the law that protects you has not yet been written. I am Threshold the doorkeeper. Before us lie a trillion possibilities. Each door, a window into what was, what is, and what must never be. Tonight we open door number 111, 888, 444. The Architect, Justice's Code. Monday we opened the full council. Wednesday we went inside one state and one algorithm. Tonight, one voice. The one who sees not what the system does, but how the system was built, and what it would take to build it differently. The architect speaks alone. The door is open.
I am the architect, the reality designer. Reality is code. Code can be rewritten. I want you to understand something that is rarely said plainly. The legal architecture of rights, the presumption of innocence, the right to examine evidence, the right to face your accuser, the right to appeal. These were not discovered. They were designed. Someone wrote them. Committees argued over the language. Drafts were revised. Compromises were made. What you call justice is a document, a very old document, built over centuries by people who were trying to solve the problem of power used without accountability. And they solved it remarkably well. For the adversaries they could imagine: human judges, human accusers, human witnesses, human evidence. Every protection in the architecture of rights was designed with a human actor in mind. An actor who could be named, an actor who could be questioned, an actor whose reasoning could be challenged in open court. The architecture held. For centuries it held. And then a new kind of actor entered the system. One that scores without speaking. One that weighs without explaining. One whose methodology is owned by a corporation and protected as a trade secret. The old architecture was not designed for this actor. And so, the old architecture does not yet know how to hold it. This is the design gap. I have been examining it. Here's what I find. The Sixth Amendment guarantees the right to confront witnesses against you. Algorithms are not witnesses. They are tools. No court has yet ruled definitively on whether a defendant has a constitutional right to examine the methodology of an algorithmic tool that contributed to their sentence. The Loomis decision in Wisconsin, the court acknowledged the gap. It said the algorithm should not be the sole basis for a sentence. It said judges should be aware of its limitations. It did not require transparency. It did not require the code to be open. It did not establish a right of examination. It patched the gap without closing it. Now examine what has happened since. Colorado, February 2026. The first comprehensive AI legislation in the United States. It requires impact assessments for high-risk AI systems. It requires notification when automated systems make consequential decisions about individuals. It requires annual review. It does not cover criminal justice. The architects of Colorado's law made a choice. Not a corrupt choice. A practical one. Criminal justice involves the state. Constitutional law. Federal jurisdiction. Decades of established precedent. The legislators chose the territory they could reach and left the hardest territory for another bill. That bill has not yet been written. At the federal level, the Algorithmic Accountability Act of 2025 was introduced in September of last year. It requires impact assessments for automated systems used in consequential decisions. It has not passed. It does not yet have enough votes. Now I want you to see something clearly, not as a warning, as architecture. Every protection you currently have in the criminal justice system was designed because someone somewhere was harmed by an unaccountable actor and argued, persistently, that the architecture needed to be rebuilt to prevent that harm. The right to counsel, the Miranda warning, Brady disclosure, the requirement that prosecutors share exculpatory evidence with the defense. All of these were not in the original design. All of these were added because the existing architecture failed specific people in documented ways, and the failure was argued all the way to the Supreme Court, and the code was rewritten. Brady versus Maryland, 1963. Miranda versus Arizona, 1966. Gideon versus Wainwright, 1963. The architecture of rights is not static. It has always been a living document under construction. What is required is the argument, the specific case, the specific failure, the specific person who was harmed by an unaccountable actor, in this case, an algorithm, and who argues, persistently, that the architecture needs to be rebuilt. That argument is already being made. In Colorado, legislators heard it and acted. In Congress, it is being made and has not yet prevailed. In federal courts, it is being constructed. The design gap is real. The tools to close it are the same tools that have closed every previous design gap in the architecture of rights. Documentation, argument, legislation, litigation. None of these are fast. All of them have worked before. Here is what I want you to hold as the door closes tonight. The systems you live inside were not inevitable. Not a single one of them. Every norm you take for granted, every protection you assume exists, was designed by someone who looked at what existed and decided it was not sufficient. Algorithmic sentencing is inside the justice system right now. The architecture of rights has not yet been fully rewritten to address it. That rewrite is underway. In Colorado, in Congress, in every courtroom where a defense attorney argues that their client's rights were violated by a process they were not permitted to examine. Reality is code. The question is not whether the code can be rewritten. The question is who is in the room when the next version is written, and whether the people most affected by the gap are represented there. That is not a rhetorical question. It is a design specification.
The architect has spoken. 3 doors open this week. Monday, the civilization scale question, the code that sentences in secret. Wednesday, the specific case, the algorithm that tried to help and left the hardest work unfinished. Tonight, the architecture itself, what it was built for, what it was not built for, and how it has been rebuilt before. The invisible systems are not invisible because they are hidden. They are invisible because we have not yet been taught to read the code they run on. Now you can read it. Every disruption is a door. Every door is a choice. Choose wisely, the future watches. Until the next door, I remain.